for inviting us for this talk. I'm Lata from IPM cell at IITM. So I think this is the last session for this event, right? So mostly I think your mind would be about packing up and getting out. So without any delay, let me jump into the topic. I'll be speaking about introduction about IPR, intellectual property rights, the basics about IPRs and different kinds of intellectual property rights and the registration process involved in patenting an invention. So these are my topic for today's session. So I have kept the session very basic, assuming that you are very new to intellectual property rights or having minimum resources about the intellectual property rights. So let us begin with analyzing the intellectual property rights, the term intellectual property rights. So intellectual, it's called as creation of mind in form of inventions, or it can be art, it can be a music, it can be a software algorithms. So it can be in any form, etc. So I have used my resources and my labor to create this property. So definitely I'll have a right on it. So to enforce this right, I have to register. So that is how we define the intellectual property rights. It's a creation of mind where I create a property using my labor and my resources, and to enforce my rights, I have to register it in a legal way. It's an intangible assets. Like the tangible assets, you can sell it, you can mortgage it, you can license it, similar to your tangible assets. So I was speaking about you have to register it in a legal way, you have to register under law. But what this registration of my intellectual property gives, it gives me the protection of my entire creation. So I protect my entire creations. By protecting this creation, I exclude others from misusing my invention or my creations. So this also paves way for commercialization. So out of commercialization, I can make a revenue out of it. So I can generate a revenue when I commercialize it. So when I register an IPR under legal acts, under law, what do I get out of it? Definitely it is a revenue generating stream. So it is taken as an asset. It is capitalized in the book of accounts. So it's always an asset. It's not considered as an expense. And it can be used as an offensive or defensive tool. Offensive tool, you can use it for commercialization purpose. That is, you can manufacture your invention, you can sell your logos which you have created out of your creativity, or you can license it to some others who is manufacturing the same product. Or you can use it as a defensive tool. That is, if anyone is manufacturing a product which is similar to your patented product, you can file an infringement suit and you can get a relief out of it. The relief can be a monetary relief also. And it always puts us in a global competitive era. And in corporates and academic session, it's definitely an investment. It's an investment to your research and development. They take it as an investment to R&D department. So these are the categories who can apply. Either it can be an individual, group of individuals. It can be an assignee. Assignee means an individual or the inventor or the designer or the creator, he can assign his inventions or the creations to another person, a third person. So that person can apply on behalf of that the inventors or the creators. And community. There are few IPRs where it's given to a community of people. So the community of people can apply for it. Any foreign applicants, firms can be a startup firm or small entities or corporate sectors, and government and educational institutions, and any trust. So these are different kinds of IPRs. You have patents, designs, which is called as industrial designs in India, and trademarks, copyrights, geographical indications, and semiconductor integrated circuit layout designs. And you got plant variety protection, which is PVP Act, and trade secrets. So these are the different kinds of IPRs which is available in India. So this is an example of a single product where we have multiple IPRs included. Say the working of the laptop. the LED display and the working, the functionality of it, you can patent it. And the body of the laptop, so the design, the front view, the side view which has the USB ports, HDMI ports, all these views can be registered under industrial design. And the logo, Apple logo, it can be trademarked. And the user manual can be copyrighted, and the layout of the IC chip. It can be protected under semiconductor integrated circuit layout design. So a single product can involve many intellectual property rights. So let me go into what is patent. So do you all have an idea what a patent is? Anyone have applied for a patent or planning to apply for it? So in simpler terms, I have an idea, and when that idea can be converted into a working module, then I can go for a patenting process. I have an idea, and that idea can be converted into a working module, then I can patent my invention. Okay, so this is your book definition. It is an exclusive right, or you can say it as an illegal right, which is granted to a person. So what is this right says? It excludes others. It excludes others from misusing the invention. So you get an exclusive right or a legal right which is excluding others from misusing your invention without your permission. So you can license it and they can use it, but without your permission, they can't use your invention. So you get an exclusive, sole exclusive right on your invention. So ideas alone cannot be patented. So there are, I'll be saying about, there are two kinds of applications. One, you'll be going for provisional or complete specifications. So in provisionals, so the scope of the patents can be described, and if your results are not ready, you can specify the scope of your patent and you can file it. So within a year, you can go for a complete specifications with all the results. But the final complete specification should have all your results, either a prototype or a simulations results also acceptable. Simulation results. Anyway, if you have a working module or a simulation results, you can go for it. So, so in exchange of this right, I have to disclose my technical information of my invention in form of applications. So I get my legal right. So in the other way, I have to describe the technical details of the invention in a disclosure. So statistics says 80% of the technical informations are disclosed only in a patent literature, not in the non-patent literatures. The non-patent literatures are journal publications and conference publications. So it's a territorial right. That is, if you seek protection in India, it's only valid in India. So if you want a protection in US, you have to apply it separately and get a protection there. And it's a right to exclude others from your invention, and the owner has the sole qualified right to use your invention. No. So it's always first protect and then publish. That is the concept of the patent. So it is protected under Indian Patent Act 1970, and the major objective of encouraging patents is to for technological development and to facilitate inventions and innovations. And you get a monopoly right for 20 years. You get only for a term valid for 20 years from the date of filing your applications. Not from the grant, remember this, it's from date of filing your applications. From that date, 20 years is counted. Okay. And after 20 years, it will be moved into the public domain so that others can utilize your inventions. What is patentable? So not all inventions are patentable. There are criteria where we have to judge for a patentabilities. So mostly there are two kinds of patents available. One is a product patent or one is a process patent. So the process to make a product. So that could also be patented. So the patentability criteria are novelty. That is, it should not be disclosed anywhere in the public in any forms. So either as a journal publication, either a conference publications, nothing would be accepted. So it should not be published in the public domain. And next is the inventive step. So any technology or any inventions doesn't build from the scratch, right? So always we take, we build on the existing inventions or existing technologies. So what we have to show in the inventive step is, we have to show some technical advancement with respect to the existing applications. Say if it is a product, I have to show some performance enhancement with respect to the current product. So if I develop a drug or say a chemical product, I have to show some efficiency or efficacy with respect to the existing product. So even the economical significance, say green technologies, low cost, even that is also be counted under the inventive step. And industrial applications, definitely we develop something to be used by the public. So any inventions will have an application in any industrial domains. So these are the three patentability criteria, so which will be judged by the patent office. So novelty, inventive step, and industrial application. So who can apply for a patent? The true and first inventor who invented the applications or who invented the product, and the assignee of true or the first inventor, and the legal representative of the true or first inventors. Okay. Now again, I told you that not all inventions are patentable. There are few exceptions here. So anything which is very contradictory to the natural law. Say for example, I develop a machine where it gives only an output without any input. That is contradictory to the natural law. So you have to have an input, you should have an output. A machine with 100% efficiency, again it's a contradictory to the natural law. So these kinds of inventions cannot be patented. And the next one is anything which is hazardous to the public, say developing a bomb, a medicine which is harmful to the human beings or the animals. So those cannot be patented. And scientific formulas, business methods, these cannot be patented, but it can be protected in other forms of IPR, like copyrights. We can use copyright to protect these scientific formulas and business methods. Next is discoveries. Any form of discoveries is not patentable because there is no human interventions in discoveries. It's only already it's available in the Mother Earth and you find it. So there is no contribution from our side. So any kinds of discoveries are not patentable. And admixtures. So admixtures are like I'm combining already existing elements. I'm combining two elements which is already existing, and on that combinations I don't give some technical advancement or some performance advancement. Then that kind of admixtures are not patentable, because as a single element they are performing. Even on combination of that, they'll be performing, even in combination, they'll be giving only the same result. They don't give an advanced results, right? So those kinds of admixtures are not patentable. And the methods of doing agricultures and horticultures are not patentable according to the Indian law. And any inventions related to atomic energy, and it's not patentable. And the treatment methods, either to human beings or to the animals, that cannot be patented. So these are under Indian laws. So US and the other countries has a different exceptions. So this is the first Indian patent, deepening. He was a civil engineer. He developed a efficient pulling machine, and he sent a petition to the government asking for the exclusive right of his inventions. And the government considered his petition and granted the whole exclusive right for him, the monopoly of that machine. So this is officially considered to be the first invention, first Indian patent. And I said, I was speaking about the inventive step, right? So anything doesn't build from the scratch. You build it from the existing ones. So this patented, these are the pictures of the patented bicycles. This is the first picture says about the first bicycle which was patented. So there was problem in that was identified, and that was rectified in the second picture. The second patent. So this is how the products have evolved, and finally we've got the cycle which we are using it in the present market. So this is how the technologies or products evolve. So you have a problem, you have a problem in the existing ones, you identify it, and then you rectify it and find a solution for it, and you get patented. And always don't judge an invention by the complexity of it. Even a simple inventions can be patented. It's not necessary invention has to be very complex or very big. So you can, or a safety pin, bell pins, and Velcro, all are patented inventions. So this is, I've just brought about the story of a Velcro. This is a patented invention. The story goes like that, like a person called as a George and his dog, like they were hunting in some mountain areas, and they found some cockleburs got stuck in the fur of the dog and his pant materials. So when he examined under the microscope, he found that the external fins which was extruding out of that cockleburs, they were the one which got stuck in the pant material and the fur of the dog. So this paved for the way for the invention of the Velcros. And this is an example of Tata Nano. So this single car has got 37 patents and 30 industrial design registrations. So each parts working. So maybe the clutch working, improved mechanisms of the clutch, and the improved mechanisms of the brake systems, and the lightning system, the front end lightning systems, all these were individually patented, and even the designs, different designs, the car design, the steering wheel designs, all these were registered under industrial design registrations. So let me start like how do we go for the registering a patent applications. So initially, before filing your applications, we have to do a search called as prior art search. So this, the objective of this search is to check whether there are any existing similar inventions in the market. There are any similar products or similar processes which is available in the market. So we always request the inventors to do a prior art search once the idea is generated itself. So this will help them to refine their strategies while developing their prototype or developing their working module. And after the prior art search, you can go for an application filing. So here we have two kinds of application. One is your provisional application and one is your complete applications. So so the difference between is, so I have the scope of my project and I have few results in it, but I need, say I need a result which according to my satisfaction. I need some results to say that this is workable, this has got some enhanced performance. Then what can I do is I can go for a provisional specification. Okay, so I can file a provisional specifications and I can seal my priority date there. So, or even if you have any urgent publications, then you can go for a filing of a provisional specifications. So here the main thing is you seal your priority date. So you get the priority date for your inventions. You are ahead of others in terms of this particular invention. In that case, you can go for your provisional specifications. And next type of application is complete application. So here your invention is completely, it is completely ready. You have all the results ready in your hand. Then you can directly file your complete specifications. So here, even though you file your provisional specification, within 12 months of filing your provisional specification, you have to file your complete specifications. So that is the catch here. So once your complete specification is being filed, it will get published. The complete specification will be published in the patent journal. So next step is examination. Until we request the patent office to examine our applications, they won't take our application for our examinations. So we have to submit few forms to requesting them to carry out the examination of our application. So what kind of examination they do is formal examination and technical examination. So formal examination is while application filing and publishing or during examination, we'll be submitting few forms. Along with the technical specification, you'll be submitting the few forms. So they'll be checking whether all these forms are correctly signed, duly signed and submitted. So that is a formal examination. And technical examination is, they'll carry out a prior art search. So we were talking about the prior art search as a first step, right? They'll be carrying out a detailed prior art search to check for any similar invention in the, whether it's existing in the market or not. So once these examination is ready, there will be objections. They may find similar ones, or they may not find the similar ones, or they may have some objections in the formal examinations. So all these objections will be listed, and it will be given to, it will be sent to the applicant in form of a first examination report. So applicant will be receiving the first examination report, and he has to reply to the examination, he has to reply to the FER. So the reply will be stating that, say if there is any similar products available, if the examiner has listed some similar products which is available in the market, he has to differentiate his invention and that product, and he have to send the differentiation in form of a reply to the patent office. So that is the response to the FER. And next, even he is not satisfied with the differences, then he may call the inventors for a technical discussions. So the inventors will explain the inventions, and also they'll differentiate the objections. Also they'll answer the objections which was raised in the FER, and the hearing gets over. So after hearing, it's the grant or refusal lies in the hands of the controller. So if they are satisfied with all the answers which we have given for the objections, they may grant, or there is also chances for refusal. Like any doubts in the application processing? For Indian Patent Office, we've called, you have IP Government Online. So you can check all the applications filed here. And you have Google Patents where you can just give the abstract of your invention or something and check for the similar ones. Google Patents, you have eSpaceNet, Patent Scope. These are all free database, free patent online. All these are free peer databases where you can check for patents.
For the scope, we have to check for all countries for that patent, or just Indian patents?
It's only worldwide. You have to check for the worldwide.
So uniformly for every country it is 20 years.
Yes.
Are the technical officers professors of institute?
Not necessarily, but they are qualified examiners. The government keeper examination, they have scrutinizing examination processes, and they select based on their thing. Based on their domain, there's different kinds of examiners. Yes, if you want to protect it in countries, you have to apply in different countries.
Is there in US, so I can directly use that in India without their not like that.
So that's what ma'am explained in the this time. Before I come to some prior. So as per our patent and patent act, your idea is disclosed anywhere in any form, so whether a conference or something or whatever. Our patent office is scrutinized. As per patent and patent act, it is already disclosed. It's not patent. So if they don't find, then okay.
So like same ideas are submitted at almost a similar time, then how will they?
The dates, the priority dates, 1 day before a thing, how do you seal it?
So there are also settlement For example, on the same day, the two inventors file and there is no connection. There are separate settlement between the further discussion needed to solve that issue.
Day, time, and then they go for settlement.
That's a procedure in that way. So they follow.
And that's very rare cases it happens.
It is a free process or we have to pay for it.
Patentability,
We have to pay to get a patent or
yes, you have fees which has to be paid. So filing your application for examinations, you have few fees. It's a standardized one. For just filing your application, it's 1,600, and for request for examination, it is 4,000 as an individual or a startup and academic. And for corporates, it's a different pay thing. So, so if you don't go through, there's something called as normal route and expedited route and all. For normal route, it's just 5,600. So initial basic. But you have other things also. If you require, say, some inventors, because in your patent grant certificate, you'll have only the applicant name. If you want the inventor name, you have to pay extra amount and you have to submit a form, and you can get the inventor's name in the pre. So based on your requirements, they will be changed in the rates. So, but the basic rates, it's 5,600. Do we? Yeah, we have to pay to the government. So Indian Patent Office is under the government, so we'll be paying to get the patent.
Your house property. To protect your house, your land, you go and file some form and pay some amount to get similar.
No, definitely not, because your publication itself will be a prior art for your patent. So that's why they say first protect and then go for publishing.
that's an already patented process. I'm taking a small change in that and improving the efficiency. Now this is also better.
Yes, definitely. So filing procedure can be,
So we do an incremental improvement on a previous page. So to do that, we need to know the details of the previous page.
yes. There is open source softwares which you can, there's IP databases, so you can check for your inventions whether the similar set of key features are available or not. So as I said, INPAS is an Indian Patent Office website, so you can check for it. You have Google Patents. No, the whole document is available. You can download the whole document.
After 18 months, you open to the public.
So whole technical document will be published. So that's why 80% of the technical information will be in the patent specification. So there are two kinds of filing procedure. Either you can go for the patent office directly and file your patent applications. The hard copies of your applications can be submitted. So you know the patent offices are in Chennai, Bombay, Calcutta, Delhi, and one in the Ahmedabad. And you have to physically walk in and submit your hard copies of your forms and your technical specification. And there's an online portal available in IP India government, so you can submit an online copy. You can file e-file, you do a e-filing there. So this is the link, ipindiaonline.gov.in. So you can do a e-filing over there. So this is a screenshot of the e-filing login. So applicants, the inventors can directly file. It's not necessary any intermediate person is needed. So inventors or applicants then create your login and directly file your applications. And this is a screenshot of the patent grant certificate. So usually it will have the applicant name, and if you need an inventor's name, you have to submit a separate form for it. Okay, next is trademarks. Like, any idea what a trademark is? So marks.
Sorry, I had a question about the previous thing.
Yes, sir.
You mentioned this was industrial design registration.
Yes.
Is that different from the,
Yes, sir. That is a different type of IPR.
so for example, from the nano car,
Uh,
name is organized with a separate registration form.
Yes, that doesn't involve the functionality, only the aesthetic view appearance of that particular product you can register under the industrial design. Yeah, it comes not under patent. So patent is only for the workable module of your invention.
Repeat question on the same thing. If the patent is, an idea is a patent in US, if I can I use that in India? I'm not going to patent it, but if I use that, it's illegal.
For fair use, it's fine. But you can't produce it and you can't manufacture it and you can't sell it.
Not protected in India, right? As you said, we have to get patent in different countries.
See, so, what happens is if they find out, they may file an infringement suit against you and they can claim for relief, right?
No, no, but is the US patent applicable in India? That's the question. Because it's territorial.
There is also called international competition.
So they will be,
They will file in India. So they have filed in India. So
yeah, I think that's the question. We have the question that if it is filed only in the US, is using that in India illegal? That's what it is.
See, for fair use,
they don't come to know, no issue.
No, no, but if it is not international that they filed only in
Even
US.
they file in US, but for the company is using in India, it is not damaging their economy or whatever. They will not file it. Otherwise, if it is damaging revenue, that person will definitely still fight against
So let me put the question the other way. If I understand the question, suppose I am patenting something in India. I did not go and file it in the US. But somebody in the US is using my thing. Do I have the right to go somewhere and sue against them in the US?
definitely you can approach their patent office and you can write a petition there.
But then I don't understand this notion of territorial area that you said. Because if I patent in India, it's applicable only in India. So
See, but when we check for the whole invention, we check it for worldwide. So criteria, patentability criteria, we check it for worldwide. The right is territorial.
yeah, so if the right is territorial, how will I have the right to sue in the US?
you cannot directly go, but you can find a way that it is already protected in India. So you can get some committee or like support to sue against it. You cannot, as all the act and rights are with respect to the particular country. We cannot go and represent directly there, so, but through some channel, we can.
Sorry for hijacking the question, but did I phrase it correctly?
But lot of things are happening. As you said that we cannot directly go and fight against it. Because in China
So-
and India, a lot of things are happening.
There is no way to legally do it. So, but there's a few channels where you can go through.
Question is illegal happening in India.
This complaint, everything will go through this patent committee, or can you have to directly go to court, those kind of, how it works?
What kind of complaints?
Patent office, like the portal, is there any website through which we can apply for this complaint?
Say someone is misusing your inventions or something. This is, so when you find it, it will be you have to approach in a legal way and then you have to file a case.
Complete litigation.
Acha.
You have to find a lawyer and find a way. Other than
So in what ways the product is infringing your products, all those have to be, you have to find out and then you have to file a case against them. So the next is like trademarks. So these are marks which is going to help you in promoting your trade business. So business can be anything. So there are some marks which helps you in promoting your businesses. So we can say a trademark can be a simple word, a name, a spelling of a word, or it can be a logo. It can be only a logo, or it can be only a slogan, or it can be only a colors, only colors, or it can be a combination of all of these. So all this can be termed as your trademark. So the main purpose of the trademark is to identify your particular business, the quality of the business, and also to distinguish between the original ones and the duplicate ones. So that is your main purpose of the trademarks. So you get an exclusive monopoly when you register your trademarks. And so there are main category of trademarks. There are two main categories. One is called as word mark and one is called as device mark. So under word mark, it's just the spelling. Say suppose Reliance. So how do I spell Reliance? For example, Tata. How do I spell Tata? So that alone is called as word mark. And device mark is how do, say Tata, how do I write T? How do I write A? What font I use? What color I use? Is there any logo associated with it? All, it can be a single element or combination of all these elements is called as a device mark. And there's also something called as certification mark. Your hallmark, ISI mark, FSSAI mark, all these are called as certification mark. And there's called as collective marks. Say CA institutes will be using a logo called as C followed by A. So this is a common representation for all institutes of chartered account registered under some body, CA bodies. Say institutions, when they are accredited to NBA, they'll be using their logo. So that is all called as collective marks. So it will be used for by a community of that people. So it is protected under the Trademark Act 1990 and it's perpetual. That is every 10 years you can renew it. There is no limited validity. So every 10 years you can renew it. If you don't renew it, it will fall into the public domain and anyone can use it. So there are few marks which is not registerable. So laudatory words like say best, novel, all these, or something words which hurt the religious sentiments, or some hurtful words or symbols, all these cannot be registered under the trademarks. Even the well-known trademarks, if you change the spelling of it, all these cannot be registered. Like Indian Patent Office, we have a trademark office, so they'll be judging it. So there'll be examiners and there'll be controllers there, they'll be deciding it. They'll have some set of rules under the Act, Trademark Act 1999, and they'll be deciding it. And a few examples of trademarks. And see the Coke bottle, the shape of the bottle and the name. So together it's called as a device mark. So the Hewlett Packard Enterprise, it's just a rectangle with a green color. So the color and plus the name. It's a combination of both, so it's a device mark. And you have in Nike, you have a name, logo and slogan. Altogether, it's a device mark. So these are called as trademarks. It can be a simple name or it can be a device mark with it's a combination of all these.
If I want to change either the name or the color, or we should change both. Actually, in the recent also, there was issue like Oreo biscuit and the Parle.
Yeah, Fabio.
Just they changed their name, but the color was did not change. So Oreo, so can it happen like that?
The same case, actually, it came in favor of the Oreo. The judgment has come in the favor of Oreo. That happens. The Oreo is already a well-known brand. Just changing the name alone doesn't go well. So they filed an infringement suit, and now it came in favor of the Oreo. It's not possible. So when it is already well known and it has already, they have already built an empire. So just changing some words or the spelling of it doesn't go well. Okay.
First of all, they say WINGS, the little wings what. But later somebody gave an infringement against it, and they had to change the words from wings to double as a triple. So even the word wings, so it is not literally affecting any other thing. Okay, but still they are giving infringement. So how it is not protected?
No, I didn't get your question. The red.
My question is that if I use a word like wings,
Okay.
okay, maybe a certain other word, and somebody else gives me a certain complaint that yes, he cannot use that word wings, but how can they do that? I am not creating an offense against him. They have given this as a confusion. It is creating confusion. So it might be a little bit silly, but still they are giving it as a complaint. So I
That's
don't
an-
think that it is still can we save against that?
See, when we go for a well-established brands, that's like, it's not possible at all. Say, some local brands, so with some changes, definitely we can go for it. Yeah.
Still they have went against that.
It's like I think even a small, if they miss out a small percentage of business, it's going to be a loss for them. So,
The wings comes under trademarks and everything. The words are difficult. The words like wings and
definitely we can use it. It doesn't comes under lottery words, right? You don't say it best or thing. I hope I answered yours, or you're still in confusion. Maybe after the session, yeah, let's have a small discussion. So when your product is not registered or you have applied for the registrations, then you can use the symbol TM in your products. And once you get the registration certificate, you can use the R symbol on your product. So next IPR is your industrial design. So in US it's called as design patent, but here we call it as an industrial design registrations. So here we don't consider the functionality of the article or the functionality of the products. Only we consider the aesthetic view, how visually it appears to us. How, like, what is the back view of it, what is available at the back view, front view, and different kinds of view, what are the components available, what is configured at different views. Only that is being considered, and we don't consider the functionality of the that particular article or a device. So here it's been protected under the Design Act 2001, and the design registration, initially it's valid for 10 years. If you want, you can extend up to 5 years. So total time period is only 15 years. After that, it will go into the public domain. And you have to file a request for renewal. So unless you file it, they won't renew it. So these are few design article. And there's something called a set of articles, which means they can be sold as only a set, or they can be used only as a set. So the design registration is available for these kinds of articles also as a whole set. They consider the whole set and give you the design registrations. No, there's two criteria. It has to be sold as a whole. Only then you can go for a set of article registrations, or the article which can be used as the whole thing. Only in that case, they give you a set of article industrial design registration. No. No, they'll have, for the individual article, they'll have a separate registrations. So when it is a set, it goes for the separate set of registration thing. So there's separate registration for an individual article, and there's a separate registration for the set of articles. And after registration, this is how it will be published. The best view of your product will be published, and with all your design number, classes, all these will be published in your patent journal. So Indian Patent Office handles both the patent and design registration. And this is the grant certificate of your design. So copyright, any idea? So what can be copyrighted?
Textbooks.
Fine, textbooks. So we saw the working model goes into the patent, and the aesthetic view of a product goes into the design, and the logos, the shape, the color combinations, all that goes into the trademarks. So what is left out? What create? Journal papers, textbooks, literary works. Fine. Software algorithms, business method, presentations. So all this can be copyrighted. So that is Published, yeah, published.
But still, is that work ours or is it the publisher's work? After we are signed to copyright.
So it's usually it's author's work. It's usually the copyright is given to the
Copyright from signing.
yeah.
What is the significance of a copyright?
You're transferring the rights to them. So
What is the meaning of that transfer right?
so they can use it legally for a fair use. They can use it.
But it's still the author's work.
Yeah, it's authored works. See, until it is legally registered, in India, it says that yeah, automatically when you publish something, you get the copyright. You get the copyright registration. But until you legally register it, you can't claim anything. So you're giving them the rights to for a fair use.
Suppose our passed away and 60 years is also passed, can I actually use his article results to mine?
Yeah, definitely.
Means if I publish something today,
So lifetime of a author plus 60 years.
so my results can also, maybe somebody else can also publish it directly as it is. Means that is a legit.
Say, so if we go in that way, like everything, it's going to like cause confusions. So you get a bundle of rights when you register for the copyrights. You get a bundle of rights. So rights for yes.
Like for a journal paper, can we publicly share our work if we have signed that copyright thing with the publisher? Because sometimes conflicts arise and the publisher actually sometimes
But they'll be having some terms and conditions, right? Each publishers will be having some terms and conditions. So
it is written at like you can use it for academic purposes,
for fair use.
but for fair use. But when we are distributing on a social platform, like somebody is asking that particular research for his own research, that is under academic research, right?
Yeah. If it comes under, if you're sharing it for academic research or you're sharing it for some other purpose.
I think it varies from journal to journal actually. So, for example, some journals have the condition that you cannot keep the same version of the paper as it is downloadable on your website. Same version. But if you change some few words here and there, or if you change the font size, the paging gets different, etc. So, same document cannot be done. But some journals have stricter techniques. You cannot have this much match with the downloadable file. But they do allow academic sharing using words, downloadable files on your website. But some journals are strict. It depends. I think it varies. That's what. But it depends on the
Journal pair things. It's better to read the terms and conditions before signing, right? You get an awareness of it. So you get a bundle of rights with it. So it's that what is copyright saying is it will prevent others from reproducing your copy. So the right to reproduce is it's been excluded. So you get that right, and here you have a bundle of rights, right for reproduction, communication to public in a tangible medium, so translations, you can translate and you can publish it. So all these bundle of rights comes along with the copyright, and it's granted under the Copyright Act 1957. But even though they say registration is not mandatory, unless you protect it under law, only you can claim for reliefs. So the term of the copyrights in general, it is say a lifetime of the author plus 60 years. So the main criteria, so they consider creativity to a smallest extent, not to a major extent. So they consider the creativity and originality. So it should not be reproduced from any other which is already available in the existing ones. And fixation, that is, it should be reproducible in the tangible medium. Say suppose I'm recording a music, it has to be stored in a CD format, and it has to be communicated to the public. So that is your fixation. These are the 3 criteria for the work to be copyrighted. So these are subject matter of copyrights: your literary, artistic works, dramatic, musical, sound recording works, and cinematographic. And software algorithms, all these also copyrighted. Your presentations, business methods, all these can be copyrighted in addition to these. So the next type of IPR. See, you get the automatic right when you publish it, you get the automatic right under the author. But if you wanted to you're protect it in a legal way so that you can sue the person who's misusing your journal publications or your works, then you have to protect it under the Copyright Act. The software algorithm per se, only the algorithm part, not the working module of your software. So when in a patent, you'll have a hardware communicating with your software and producing the result. That is the workable module. Here it is only the per se, the algorithm as it is. You can copyright it. Only the code, you can copyright it. Algorithms which communicate with the hardware. As per Indian patent law, it's an algorithm per se is not patentable. But when you give it as a whole device or a whole system, so when it communicates with the hardware and it can produce some outputs on your software with the help of the software, then it's patentable. You have to check whether it is patented in US, because US it's allowable. US patent, but under the Indian patent as a whole device, you can patent it. So the next kind of IPR is geographical indications. So do you all know which is the first GI in India? So do you all know what is first GI, geographical indication? Yes, sir. There are forms like the patent and design. There's a form. Yeah. Yes, you get the registration certificate. There's a process. As it is, it should be original one. It should not be reproduced from already existing ones. It should be from the author or from the one who coded it. So if it retains the originality, it can be copyrighted. That is for educational and fair use, right? It need not be copyrighted. For fair use, you can use it for teaching others. No, I didn't get you like. You're talking about patents, okay. No, ideas alone cannot be patented. You should have some working module of your idea. At least with some simulated results, we can go for patenting. So you say there's an already existing product. You have some idea on that existing product. Okay. So you have to show some working functionality. So idea alone cannot be patented. A copyright, yeah, it can be copied. So geographical indication, like it's given to a specific product. So with that particular product should possess the quality of the possess some quality with respect to that geographical locations. Say for GI, India's first GI is Darjeeling tea. So when this tea was patented, so the quality associated with that particular product and the quality associated with that particular region was the weather, the climatic condition under which the tea plants were grown, and the soil that contributed the freshness of the tea leaves, the taste, the smell of the tea leaves. So these specific qualities has to be identified with respect to that product. So if you identify that product, you can go for a GI. So every region has some specialty products. So you can try for a GI. So every areas have some specialty which is not known to people. So you can approach the GI office and get a GI. So Chennai Patent Office is one of your geographical indication of GI office. So again, registration is done under the GI Act 1999 and the term of GI registration is perpetual. So you have to renew every 10 years. So these are few GIs. So this is a community right. It's given to not to an individual person. The community who's producing it, who's manufacturing it, it's given to it's a community right. And when you're specifying the product, the area has to be demarcated. And you have to also specify the significance of that product with respect to the geographical locations. Anyone knows any other GI with respect to your place of origin? But is it an Indian GI? Parmesan cheese. It's with respect. Okay. So anything with related to India?
Recently there was something between Odisha and West Bengal for the rasgulla.
There's lot of clashes for basmati rices. There's a lot of clashes going on. See, that particular origin, that geographical location has that specific conditions to grow that particular product. To indicate it, to promote it, the government has brought it. Say Kanjipuram silks, so it can be manufactured in Kanjipuram. So maybe how they are, the threads, how the weavers are weaving it, all that matters. No revenue. The main thing is to promote the products. Yeah, kind of like maybe to bring out the old things. The government has just now come up maybe 20 years before. They have come to promote which is the products which is almost in the extent stages. So they wanted to promote these kind of products. Even in airports, you will have GI products. I think few airports have stalls with GI products just for the brand promotion because these communities are almost extinct. So to promote them, to give the community right for them. So do you all know which is the highest revenue generating GI? Tirupati Laddu. Fine. Exactly. So It's not that reproducing a thing. It's just to give a recognition to that product. A kind of recognition to that location and to that product. So the next is semiconductor circuit and layout design. So SIC, like the element which is consisting of transistors and circuitry elements, which is inseparable, which is separable and have some circuitry functions. Plus, they should have a layout design, like how they are connected to each other, how the elements are connected to each other. So these together can be registered under SIC LD Act. So again, it's only 10 years from the date of registrations. So this is an example of SIC, the layout design. It's an ISRO product, TR, transmitter receiver, and these are the specifications where you have to mention like this, what are the characteristics regarding the SIC. And there's other forms of IPs. One is the PVP, plant variety protection. So this is mainly to encourage farmers to come up with the new different varieties of plants. So its main purpose is to just to encourage the farmers, and those new varieties are protected under PVP Act. And again, there are some criteria where the plant variety will be judged, like how there is a patent criteria. There are few criteria where they'll be judging the whether it's a new plant or already existing ones. And next is a trade secret. It's like so a confidential information of a business has to be maintained, but in India there is no specific law for protecting a trade secret. So in US we have a specific law, but in India we don't have a specific law, but it is protected under various provisions of legal acts. But we don't have a separate law like Patent Act or Industrial Design Act. So this is a few examples like Google search algorithms, Coke formula, and KFC recipes, which are being protected under trade secret. So first one, just to end up, it's always try to protect and publish your creativities, creations. No, it's not accessible. It should not be the purpose of the trade secret. It should not be disclosed to the public in any forms, in any medium. That is the purpose of the trade secret. It's a business secret which has to be maintained.
But do they have to disclose it to the authority?
Yes, yes. The authority, the
Formula, how they prepare that. So it will be confidential between the IP office and the model.
But if by any chance if two guys are having the same trade secret, do they even know?
Is it? Oh. No, the exact one. Okay, then maybe I'm sorry for it. Yeah, the farmers and the breeders. Yeah, it's mainly for the farmers or breeders or the community related to farming. On behalf of the farmers, they can go. Any organizations? You mean any organizations or research institutes? You mean to say the research institute had come up with a plant variety? Yeah. They have to go through. It's called as DUS, distinct sustainabilities. It should be very distinct. The main criteria, like how do we say novel? Here it is the distinct. It should you have to have a major distinguish between the already existing ones and the new one. How, like even the sustainability is considered. How long?
There are many varieties like new variety, extant variety, like farmers varieties. There are several types. The procedure also varies.
See, like any other questions?
Suppose if some product were developed, the proof of legal idea, and they were patented at that time. And after certain time, some disputes were happened within the group. So at that moment, what will they do? The same patent.
Uh, See, like they can apply to the controller asking for what can be done. So they can state what is the dispute, and they can a form can be submitted to the controller stating to solve this disputes. So he may call up about them, and there would be a hearing, and based on the hearing, he may give the judgment. So it's again up to the inventors. They can follow or not follow it. So yeah, some compromise. He'll call up for some compromise. So you can approach the patent office for these kinds of disputes.
Can a student use the institute's logo in like CV?
Yeah, I can use.
Can a student use the institute's logo? Institute logo in like CV or presentation?
On behalf of the institute, if you're doing it for on behalf of the institute, that's possible. So anyway, if I present on behalf of our IITM, I can use the institute logo.
Are there common practices included in checking, cross-checking for patents?
Maybe like the patent office across the globes or something.
Actually, there was this one case where in US somebody tried to patent the masala for Hyderabadi biryani, something like that. So that type of thing.
See, one thing, when we do a prior art search, that is the common search they do all over the patent offices. And here, yeah, because there's million of data is available there, so there is a chance of missing or something. So in that case, we can go for if they find if that Hyderabad biryani masala, that patent owner, if he finds that someone is infringing or someone is misusing his invention, he can claim for infringement.
Masala is being used for centuries in Hyderabad, but
They can revoke the patent. He can revoke the patent. So you know, neem and turmeric all were earlier patented in US and UK, but they have revoked the patent, stating that it's India's traditional knowledge. Definitely, you can revoke it.
Suppose the patent is filed, so it has 3 to 4 authors, like 3 students or one professor. So what about rights? Like, is it like first author, second author, or the rights are equal?
The rights are equal.
Rights are equal. And what about the time frame we get the patent? Like when we file patent and when we are granting that patent?
It's 20 years from the date of filing. The term is.
Like there are two routes actually. One is the fastest route, that is if you are a startup or academic institution or individual, you can file for early publication, the expedited examination. So if your invention is eligible, it will be granted in 8 months to 1 year. But if you are going through normal route, it will take on average 3 years, 2 to 3 years. Earlier it used to be 7, 8 years. Some of the
So this fast route is for startups and
Yeah, academic individuals.
So extending to this question, is there an author order in the patent, not in terms of rights, but the way it is written? Is there an author?
There's no.
there is no order.
No order. It's how you give it in the forms. That's
I
it.
can claim that I have written the patent.
You have filed the patent.
You have
So you are
whether
the inventor, one of the inventors of
Yeah.
application. Like that you can.
all the authors have the equal, all the inventors have equal rights, and there is no specific order on how you specify.
Yes.
Uh,
Can surgical procedures
no, no. In India, according to India, it's not patentable.
So patent is filed first based on research methodology, and how much of it can be revealed in the journal after how much time?
As what data you have covered in patent, that whole can be revealed in the journal also after filing. After filing, not any extra informations. Immediately after filing, you'll get an application number. So immediately after getting the application number, you can file your journal publication. Yeah, you can. So, but yeah. Yeah, whatever it's disclosed in the patent application, you can disclose it in your publication, but not any additional informations, additional results or whatever it is.
Data in DVD, again copyright.
So it is like first I have the patent, then I am publishing my paper, journal paper. So it is allowed for me. It is not allowed for other person who is publishing some journal based on my patent.
Based on your patent. No, I understand your question. The thing is, if you have filed a patent, okay, somebody else copied the information from the patent publication, publishing it in a journal. Right? See, if they publish the same thing, you can, as per the journal terms and conditions, you can let them know the journal today. The idea has been filed, so plagiarism, nothing is
So the reviewer has to know, like it's already published.
So you can send the notice. You can resolve that.
Yeah.
Actually, in case when we are publishing our applied patent, we are transferring some rights of that research to the publisher, right? So is that allowed?
Like maybe I have to check on it. So I think like depends on, again, it depends on what rights you are assigning to the publisher.
Actually, by default, one of the condition is whatever is mentioned in the paper,
He has the
publisher also has some say on it. But according to the patent office for the patent rights, nobody other than the inventors has the right on
right on it. So one thing, when publishing, you can mention the patent pending and application number in your publication also to overcome it. Maybe I'll check on it. I'll check on it and I'll get back.
So let's thank
Maybe it's 5:30. Show some pages that where they can explore that.
Sure. Maybe I'll just, so as a token of our appreciation.
So we too.
Hope you all gain some knowledge about the web.
You have also thrown some very good questions that we'll go and visit and correct ourselves. So,
It was also a smaller group. Last
anybody knows to connect with the internet?
you want to connect to the internet?
Yes.
Oh, okay.
Mobile.
Yeah.
So then I can use my mobile.
Yeah, IITM Wi-Fi doesn't connect.
At ICSI we used to connect with that, but here
Oh,
it's
then?
not working.
No, ICSR
We have IITM there. IITM Wi-Fi.
It should work. Doesn't connect. Yeah? It's Wi-Fi.
That's what it means. Used to happen. ask questions.
Okay, yeah, so you can show that.
Let me see. Yeah.
Okay, so it's going to show some websites where you can get more information. So in case any of you want to go out, see deeper.
So ma'am explained about the patentability criteria, and before you file you must do prior art search, and she also said that a few examples where you can look for prior published patents like Google patents and WIPO, patent scope, all these things. Indian Patent Office. So have anybody has opened the Indian Patent Office website previously? So just thought it's not audible. I thought my mic. Oh. Okay. Okay. Hi. Yes. Lada madam has explained about on all the forms of IPs and patent procedures, filing procedures, and then so what you have to do before filing patents. So there was a point that you must look for searching prior published patent applications. So I would like to show where you can actually check for prior published patents. So there are few websites. So the first open source is Google Patents you can use. So mostly Google Patents covers major countries, the patents protected in various countries like US, UK, and then Australia, all these jurisdictions, the patents are protected in these jurisdictions. Indian patents won't be available on Google Patents. But so putting keywords like if you have any like term clean water. What happened? Maybe I have to share the screen. PowerPoint worked perfectly.
So is he on a call? Zoom? No, you're on a Zoom call?
No.
So how are you recording? Is it on a Zoom call? No, sir. No. So
Is it coming? Yes. Okay, thank you. Sorry for that. Yeah, you can look at the Google Patent website here. So you can put keywords like whatever you have, key features with respect to your ideas, like clean water. I'm just putting few examples, and nano filter, and few like. So if you search, there will be several patents, and you can look at the complete details by clicking on each. So abstract and the complete specification, you can glance through it. Whether your ideas are, maybe you are in the starting stage of your research or project. So you want to know that where your research stands. So you can probably you can glance through these. The Google patents and put your keywords and find the list of patents, and you can check the gap between your ideas and the already existing technologies. And also you can look at Indian patent website. So this is the search page. So you can search based on the title or abstract and the application number if you know. And so in the complete specification area or abstract area, you can just put, for example, you can put semiconductor, and you want to, if you have any specific keyword, you can put it. I'm just showing you here. We have CAPTCHA here with respect to FQ80X. This is the problem with the Indian Patent Office website. It always asks some CAPTCHAs. But sometimes IP professional get tired by typing each time. Yes. So you can find what are the patents filed in India by putting keywords based on your requirement, and you can click on the application number to see the complete details. So this is where you can go through Indian patent website and find the relevant patents. And there is also a website called eSpaceNet. It's European patent database. It's this is the wonderful search engine. It covers most of the and are like smart search and advanced search. The option you in smart search you can select keywords and you can do that. In advanced you can like you can refine your search or restrict